Chapter 14 is on contracts. First of all, let's define what a contract is. A contract is an agreement among parties. And actually, the real definition, it is an exact and mutual meeting of the minds. It's what all the parties know that all the parties have agreed to. In order for us to have a contract, first of all, it's got to be legal. In other words, we can't contract for something that is illegal. There's got to be some consideration involved, and that could be promises, it could be money, it could be any number of things. And the parties need to be competent. That is to say, they need to be at least 18 years or older and mentally competent. As far as contracts and what licensees can and can't do, we are allowed to prepare sale and purchase agreements. We're allowed to prepare listing agreements and also option contracts. Now, what we are not allowed to do are conveyance instruments. Again, a conveyance instrument is something that conveys an interest in real property from one person to another. For instance, a deed. A deed conveys interest, it conveys the actual title from one person to another. A mortgage conveys the right that a lender has to foreclose. One other conveyance instrument that you need to be aware of are leases. What a lease does is it conveys an interest that somebody's allowed to live in a property even though they don't own it. So those are the three basic conveyance instruments that we are not allowed to do. The statute of fraud says that certain contracts have to be in writing to be enforceable. That's not to say that an oral contract is not a valid contract or legal. It is. It's simply not enforceable. So those contracts that have to be in writing to be enforceable, the sale and purchase agreement, an option contract, leases for more than a year, and also your exclusive right of sale listing contract. Those all have to be in writing to be enforceable. Now, there are certain circumstances where they've deemed that certain oral contracts have been declared to be enforceable. We call that partial performance or the partial performance doctrine. But what has to occur is that first the buyer has to put up a deposit. Then secondly, the buyer has to either move in or start repair. So in other words, it's got to appear that there's some type of an agreement. As far as void and voidable are concerned, remember that a contract that is void means it doesn't exist. A contract that is voidable means that it exists but could become voidable. Let me give an example. If an unlicensed person entered into a listing agreement, that listing agreement is void. That person that was unlicensed did not have the right to enter into a contract. That was illegal. The question has always been, can you enter into a contract with a minor? Well, the fact of the matter is you can enter into a contract with a minor. But I want you to remember that when you do, it's a one-way street. The minor can enforce it against you, but you cannot enforce it against a minor. So that contract is truly voidable. If the minor decides they want to void it out, they can. You have no control over it. As far as the essentials in the contract, obviously the individuals need to be at least 18 years or older and mentally competent. In contract law, there has to be an offer, there has to be an acceptance of that offer, and there has to be a communication back. Without that communication back, you do not have a contract. So anytime that you make an offer, that offer is non-contractual. And even if you have an acceptance of that offer, it's still non-contractual. Doesn't become contractual until there's been a communication back, and typically most of our contracts say that this communication needs to be back in writing. There also needs to be legal, and there needs to be some consideration. As far as classifications of contracts, the difference between a bilateral contract and a unilateral, think about how many wheels a bicycle has on it. It has two, which means in a bilateral contract, two parties are promising to do something. A unilateral contract, or a unicycle, one wheel. In a unilateral contract, only one person is promising to do something. So what's the difference? A sale and purchase agreement, the buyer promises to buy, the seller promises to sell. But in an option contract, only the seller is promising to sell, the buyer is not promising. In an option contract, the buyer has a look-see, and they can make up their mind later if they want to buy or not. As far as executed and executory, a contract that is executory means something is remaining to be done. For instance, in a sale and purchase agreement, when the buyer and seller come to an agreement, what's remaining to be done is a closing. So it's considered to be executory. Once they have a closing, there's nothing remaining to be done. That's considered to be executed. As far as the parties to contracts, you have offerors and offerees. And let me say this. Let's make sure that we understand. ORs always give something. EEs always receive something. So we have the offeror, the person giving the offer, and we have the offeree, the person that's receiving that offer. And once again, in contract law, offer, an acceptance of that offer, and a communication back is going to be required. And I also want to caution you that at any time that if a buyer makes an offer on a property, puts up earnest money, any time until it's been accepted and then communicated back, that person can withdraw from that offer and get their money back. It's non-contractual. As far as termination of offers, I like acceptance. I like it that when somebody accepts an offer, then it's over, then we move forward. Parties can withdraw. Remember I said that at any time, actually either party can withdraw. Offers can be rejected. If a seller doesn't like it, they can say, hey, I don't like it, send it back. What we mostly see, though, are something called counter offers. And that's when they reverse roles, where we have an offer that comes in, that person who receives that offer says, I don't like it, I want to change it. I'm going to tell them what I like. Well, that's a counter offer. I want you to remember, though, that in any counter offer, the old offer becomes null and void. And you can't go back to it unless both parties choose to go back to it. Also, a lapse of time. Obviously, if you put a time frame in there, if it's not acted on, it's going to expire. Regarding contracts, though, once it becomes a contract, the question is, now how do we terminate this? I like performance. That's where we go ahead and go to closing. There's also mutual rescission where both parties say, let's both just decide to withdraw. The one that we worry about the most, though, is breach. Breach is where one or the other parties decide that they simply don't want to go through with the transaction. And when we have breach, there are a number of remedies that we can do. If it's the buyer that breaches, the seller can keep the deposit as liquidated damages. Now, let me say this also, that when it gets to specific performance, a seller has two choices. They can either keep the deposit or sue for specific performance, but they can't have both. Most cases, that's why we collect an earnest money deposit, is that we want to have that money available in case the buyer decides to change their minds and decides to back out or breach. There's also unliquidated damages that can be ascertained at a later date, maybe even through a lawsuit. As far as contracts and assignability, the way that contracts work is that all contracts are assignable unless there's something very specific in them that does not allow them to be assigned. In other words, I enter into a contract to buy property from you. If it says that I can assign or does not say that I can't, then I can sell that contract or I can assign it to somebody else and let them fulfill my obligations. But I think it's worthy to note that if I do an assignment, that I'm still on the hook. Unless that seller or whoever I'm dealing with gives me a release of liability, we call that novation, by the way. Unless they give me a release of liability, I'm still on the hook. As far as important real estate contracts, one of the major contracts that we're going to be dealing with in this business are listing contracts. A listing agreement is an employment agreement. The listing agreement is between a seller of property and a real estate broker, keeping in mind that a real estate licensee, a sales associate, may be the one that obtains the listing, but they do that on behalf of the broker. They are acting as a sub-agent. So in a listing agreement, we have a variety of types of ways that we get paid and the way that we perceive these listings. One of the ways that we get paid in most of the cases, that if we find a buyer who is ready, willing, and able at a price and term acceptable to the seller, we've earned our fee, whether we go to closing or not. The other way that we can be compensated is that if we obtain a buyer, take it to closing, and then get paid. So there's a couple of ways that we have to look at it. Also, let me caution you that licensees are required by law that once they enter into a listing contract with a seller, that a copy of that listing contract has to be delivered to the seller within 24 hours of its execution. Now we're a postmark state, so you can always mail it within 24 hours, but it has to be sent or delivered within 24 hours of execution. Now, what are the kinds of contracts that we deal with, the types of listing contracts that we have? The one that's probably the least effective and the one that is least wanted is the open listing. And here's what the open listing says. The open listing says, Broker David, I'm going to list my property with you, but I reserve the right to list it with other brokers, and I also reserve the right to sell it myself. And the only way that you're going to get paid is if you sell it. In other words, if I sell it myself, you're not going to get paid. Most of us don't deal very well with open listings. Another type of listing that we deal with is called the exclusive agency listing. And what the exclusive agency listing says is, Broker David, I'm going to list my property with you exclusively as the broker. No other brokers will be involved. But I still want to reserve the right to sell it myself without owing you a commission. That's a little bit better, but it's still not what we're looking for. The most desirable listing contract that we have is the exclusive right of sale listing contract. And what the seller says is, Broker David, I'm going to list my property with you exclusively and no other brokers. And no matter who sells the property during the listing period, you will be paid regardless. It doesn't matter. Now, one of the things that we talked about in terms of canceling listing agreements, I want you to remember something. A seller may have the power to revoke a listing contract, but they may not have the legal right to. So the deal is that as long as I have that listing and it's active and I've not breached, and that property sells during the listing period, I'm going to be paid. A good example might be a seller decides they want to cancel one listing and relist it with another broker. Well, they need to be careful. Unless there is a release clause that allows that to happen, that seller may very well be subject to 2 different commissions if that property sells. Another type of listing that we need to be aware of is called the net listing. The net listing is where we promise the seller a certain net amount at closing. Now, this can be a little difficult in some cases, and also we need to be very cautious, and let me say why. The state of Florida says that we cannot gouge our client, which means that when we sell it and we net that seller a certain amount, that our compensation cannot be any more than it would normally be under normal conditions. In other words, we can't have excessive fees. As far as procuring cause is concerned, procuring cause has to do with the person that created the desire to purchase. Typically, it's the person that got the name on the dotted line. Speaking of that, let's talk about sales and purchase agreements. The sale and purchase agreement is between the buyer and the seller, where the buyer promises to buy and the seller promises to sell. Up until the day of closing, the seller of the property still has legal title. Now, the buyer does have an interest. The buyer has what we call equitable title. And what that basically means is that once the seller has committed to selling to a buyer, they cannot arbitrarily say, you know what, I think I'm going to sell it to somebody else. That would be illegal. Now, as far as the sale and purchase agreement is concerned, you're going to have the time, date, and place of closing, your purchase price, the legal description, financing, the quality of title that's going to be delivered. A number of things will all be spelled out in that sale and purchase agreement. In addition, there are going to be a number of disclosures that we as licensees have to make prior to entering into contracts. Radon gas is an odorless, colorless gas that seeps into houses. A buyer has to know that they've got the right to have it inspected for radon gas. They also have the right to inspect for lead-based paint. Now, lead-based paint only applies to those homes built prior to 1978, and also any facilities, commercial facilities that house children, such as daycare centers. So we're only talking about residential properties built prior to 78. Also, energy efficiency disclosures have to be made. If there's any homeowners associations, if it's condominiums, obviously those condominium documents have to be delivered. Flood insurance. Now, let me make a comment about stigmatized properties. A stigmatized property is a property where there's been a homicide or a suicide. Let's make it perfectly clear. In the state of Florida, the legislators have decided and made it law that a property that is considered to be stigmatized, this is a non-disclosable event for licensees. In other words, it's not a requirement for disclosure. Regarding an option contract, an option contract is between the optionor and the optionee. The optionor is the giver of the option, who is the potential seller. The optionee is the potential buyer. Remember, we said that an option contract is an option contract is unilateral. Only one person is promising to do something, and that is the potential seller. The buyer has the right to take a look and make a decision whether they want to buy or not. Now, in contract, since both parties have to have some consideration, since the buyer is not promising or the optionee is not promising, well, we say they have to put up definite, valuable consideration. Typically, that's money. The question might be, is that money refundable or not? It's all negotiated between the optionor and the optionee. The last thing is the installment sale for contract, or the land contract, or contract for deed. There's a number of terms that you can use. What a contract for deed is the sale of real property where there's not a closing and a deed does not transfer. Rather, what happens is a document is recorded on public record saying that the seller will give a deed at a later date when certain conditions are obtained. As far as defects in property, and this has only to do with residential properties, the Florida Supreme Court in the Johnson versus Davis case came out and said that if a seller knows of a latent material defect, that is a hidden defect that will affect value, that they must disclose that prior to entering into a contract. This has nothing to do with commercial properties. It has to do with residential properties. And so if a licensee is involved, they need to ask the proper questions to make sure that there's not a latent material defect that's hidden that has to be disclosed. Sometimes sellers think that they don't have to if they sell a property as is. That's not correct. Even if you sell a property as is, if you know something, it still has to be disclosed no matter what. And that's the end of Chapter 14's contracts. And what I'd like to do right now, I'd like to go ahead and review the contracts with you real quick. To begin with, the statute of fraud requires certain contracts to be in writing to be enforceable. The statute of limitation allows actions to be taken within 5 years of a breach. A partial performance doctrine is a doctrine where we have an oral agreement and can be enforced if, first of all, part of the purchase price is delivered, and secondly, a buyer has been either allowed to move in or to start renovations. Contracting persons should be at least 18 years or older and mentally competent, although they don't necessarily have to be, they should be. Contracts with minors are what we call voidable. You must have an offer, an acceptance of that offer, and a communication back in order to create a contract. The breach of contracts can be remedied by either liquidated damages, given only to the seller, specific performance, and unliquidated damages. Listing contracts, and there are 3 of them: the open listing, the exclusive listing, and the exclusive right of sale. Remember, the exclusive right of sale is the best listing that we're looking for. Also, we have a net listing, that is guaranteeing a seller a certain net amount at sale. Remember that licensees cannot gouge sellers. The sale and purchase agreement, the seller has legal title to closing, and the buyer has equitable title up until the closing. The required disclosures that we have to deal with, radon gas, and lead-based paint, which affects homes built prior to 1978. Also, option contracts are unilateral. And that's the end of Chapter 14's review.